All right, so this is the offer to purchase and contract. It is written by the North Carolina Association of Realtors and the North Carolina Bar Association. It's definitely seen some changes over the years, but this is the current version, and it is, in a nutshell, an offer form that, once accepted by the seller, turns into the contract. So it's just kind of like a two-in-one form. Super straightforward, super detailed as well. So we're going to go through it together, and hopefully it'll address any issues or confusion you have up front. And if you do have any questions, of course, please give me a call or email me, Stephen@costellorei.com, with any questions that you may have. So let's go to get started. I'm going to try and breeze through it, hopefully with enough meat, so that way it's not too quick. But I definitely want to make sure we cover all the bases. First section here is just terms and definitions. So it's basically like any legal contract. It's going to define what's going on here. So who is the seller in this scenario? Who's the buyer? And we'll usually put, if you're married, we'll put a married couple at the end of the names. If you're single, we wouldn't need to do that. If you are in a relationship and buying this property jointly with another person, then we would put both the names, but we would leave off the married status. So you'll see that. Don't be surprised by it. It's just because it's legal. We got to do it. Property. So what's the street address, city, county, zip, all that, like mailing address. But then what's the government description, like the legal description, and that's stuff that I'll fill out for you. I'll fill out all this stuff. Lot, unit, block, section, subdivision, plat book, PIN number, any of that information. I'm going to look it up for you. That's why these things take a couple minutes to write. It's not super easy. So that's why, if you say, I want to make an offer, that's great. We'll do a verbal offer, but then this is what needs to be submitted later and signed. Purchase price right here. This is how much you're agreeing to pay for the property. Due diligence fee is how much you're agreeing to pay in due diligence. So remember, we've talked about this before, and if not, I'm going to talk about it. But the due diligence fee in North Carolina is a fee that you pay to the sellers up front to once the offer is accepted. So of course you can write the check all day long, but if your offer is unaccepted, you're not paying that money. But if the offer is accepted and this becomes a contract, the due diligence fee is made payable immediately to the seller. And that is typically given for taking their house off the market to investigate the property and do your due diligence to make sure everything is what they said it was online and what you saw on the first walkthrough, and just make sure that this is the house that you want to buy, basically. But it's a fee, and so it is not refundable if you decide to back out of the purchase. It is, however, refundable as a credit towards you, the buyer, at closing. So let me say that again. Due diligence is not refundable at all if you back out of the deal before you close. Now, if you do decide that you want to buy this house and you go under contract and you see it all the way to closing, this due diligence fee is given back to you as a credit on the closing disclosure towards the purchase price of the house. So the money's not lost, but it's certainly the most losable amount, if you will, in the beginning of the transaction. The difference I'll talk about in a minute between this and the earnest money deposit, but the earnest money deposit is a check made payable to the escrow agent, typically an attorney or someone who holds title to an escrow account. My firm does not hold escrow, but attorneys typically do. So you would write the attorney's name on the check. You'd make it payable to the attorney, and they hold it in what's called an escrow account. And again, that is like kind of a limbo. That's a no man's land of funds. It comes out of your account. So all of these numbers, the due diligence fee and the earnest money deposit, both of those come out of your checking account. But due diligence goes into the back pocket of the seller, and they can go to Miami if they want to for the weekend with that money. It's gone. Once it's accepted, it's theirs. Earnest money, however, it comes out of your account, but it goes into escrow. If you back out of the deal before you decide to the end of the due diligence period, which I'll talk about in a minute, if you back out of the deal, then you will get your earnest money deposit back, but you still lose your due diligence fee. So let me say that one more time. If you back out of the deal before the end of the due diligence time period, you lose your due diligence fee, but you get your earnest money back. If you back out of the deal after due diligence has ended, the time frame that we'll talk about in a minute, but before closing, so in that last second half of the window there, you lose both. You lose both the due diligence fee, as well, just because it was a fee, and the earnest money deposit as damages to the seller for taking the house off the market. That's a big one because that's a bigger amount usually. Sometimes you can see a due diligence fee as 1% or more of the purchase price. I'm sorry, earnest money deposit as 1% or more of the purchase price. Due diligence fee, however, is normally not 1%, but sometimes it can be as much as 1% or more as the purchase price of the property. I usually see due diligence fees anywhere from $500 to $1,000, sometimes higher. But yeah, typically they're a smaller amount that is made payable to the seller. Additional earnest money, that's just if you want to show additional dedication, that can be provided at a later date. So maybe you want to say, all right, we'll give you $500 due diligence now with $1,000 earnest money. And once you go under contract and due diligence is expired and everything checks out, we'll give you an additional $2,000 in earnest money. It's rare that that happens. Some people do it, but you might want to do it just to show like that you're really, really serious, but you definitely want to investigate the property first. So that's an option. These other sections are rare, but it's assumption loans, seller financing, builder deposits. All of these are rarely used. If we have to use them, I'll explain them. But just know that the first three are, these three sections here are usually where you'll see the most amount of money. Hopefully you're with me still. All right, so like I said, earnest money deposit is a deposit, like it says, it stays in the escrow account. It is refundable if you back out of the deal, unless we are too close to closing, as in we are due diligence has expired and we are now kind of on the fast track to close. That is not refundable at that point. So that keep that in mind when you're going through this process. That earnest money is refundable up to a certain time period, whereas due diligence is never refundable. Both of those, however, earnest money and due diligence, are credited back to you at closing towards the purchase price of the home. Not like a down payment, just towards the purchase price of the home. So it is different from your down payment. Escrow agent, usually the attorney, but could be someone else. All right, effective date, that is the date that it is signed. So when everyone has signed, both parties, boom, effective date. You guys are under contract, congratulations. You may start making moves towards due diligence. So due diligence here is your opportunity to investigate the property. Usually it's a time frame, so we'll assign a time frame to it, 2 to 4 weeks maximum. I've seen longer, but usually I'll say 2 weeks is what we need to hire inspectors and to go out to the property to make sure we want to buy it. After that time period has ended and before closing day, that's kind of like the last few weeks, usually the last few days of escrow. That's when you are at risk for losing your earnest money deposit. But if you're still in the due diligence time period, which is right here, we'll say it right here, time being of the essence, 5 p.m. through the effective date through 5 p.m. If you're still in the due diligence period and you back out, you lose the due diligence fee, but you get your earnest money back. And that's the way it works. But if, say I put in here say it's March 21st, say I put in April 1st as the end of due diligence, then after April 1st and you back out of the deal, you lose it all. But if you back out of the deal before April 1st, you only lose your due diligence fee. Hopefully that makes sense. I've said it a bunch of times. If not already, I apologize if I'm sounding like a broken record, but I really want to make sure you understand that because it's very important. Okay? Settlement is closing. Settlement date is our closing date. Closing, well, they talk about more the legal process. It's just like a hearing, basically. You do need to be at closing. If you're a buyer, you need to both. If there's two of you, you need to both be at closing. If there's multiple buyers, you all need to be at closing. Everyone needs to be at closing. Bring your, state issued ID with you. There will be closing costs involved. Just know that you need to be there. This talks about assessments, special assessments on the property, proposed and confirmed. Proposed meaning, say, the HOA, if you're in a property that has an HOA. If they have formally decided that there's going to be a special assessment, they've proposed it, but they haven't voted on it yet, it's not confirmed, then that the obligation to pay that assessment is going to lie with the seller. If the special assessment is confirmed, whether it be an HOA, they need to repave the roads or something like that in the HOA, or the state needs to do it, and they've assessed an assessment, then confirmed assessments need to be paid for fully by the buyer at settlement. So that's something you'll want to make sure to ask when we're going through the process. Okay, is there an assessment on this property? Fixtures and exclusions. This is my favorite part. So all of these that you see here are talking about fixtures. So what is a fixture? What's not a fixture? In North Carolina, surprisingly, a refrigerator is not a fixture. It does not stay with the property unless you ask for it. TV mounts, like wall mounts, are fixtures, whereas the TVs themselves are not fixtures. So just knowing those subtle differences is important. It's strange here too in North Carolina that curtain rods are fixtures, but curtains are not fixtures. So just keep that all in mind. And I'll talk to you more about all of that as we continue through the process. Let's see. Okay, so then this is where we get into the things where we can ask a little bit more about ask for things from the seller. So if the seller has identified things like fuel tanks or antennas or satellite dishes as not as their leased items, then they obviously will not convey with the property. We'll just make sure to expressly reiterate those here in the contract. If there are some things that the seller has decided to do not convey, like grandma's chandelier in the dining room or the doorknob on the front door because it was an heirloom, those are things that we would express here as well and make sure everyone's agreed upon them. If there are personal items that you as the buyer want from the seller, like a refrigerator or washer and dryer, we can't buy them. We can buy them from the seller separately on a separate bill of sale, and I'll get to that later. And if not, just remind me and we'll talk about it. But if you want them to be conveyed at no value, meaning the seller just leaves them and no money is exchanged explicitly for those items, then we'll put them here. So most of the time I'll put a refrigerator in the kitchen or maybe the beer fridge in the garage or something like that. That is what we'll put here in personal property. Or you like the curtains, we'll ask for them, we'll put them right here. Let's see. So we talk about the due diligence process here for the buyer. There is a warning here. It says you're strongly encouraged to conduct due diligence during the due diligence period. Most people do. So be due diligent. And so that's just a warning to you. Just be on top of it, basically. Like you got to get all your ducks in a row, get the loan squared away, investigate the property, and I work with you to coordinate all of that information there. I'm like a project manager, if you think about it. Set up utilities, all of that stuff. We just need to make sure that it's all done. And I'll keep you on track. I'm your agent, so I want to make sure you're on track with it too. We'll negotiate repairs, and when this talks about that section here, buyer's obligation to repair damage. If you damage anything in the house while you're under contract, then you have to fix it. Sorry, it's just the way it is. Then we talk about right to terminate. You do have the right to terminate in North Carolina. But of course, it's got to be during the due diligence period in order to get your earnest money refunded back to you. If not, then the earnest money is not refunded to you. Let's see. So keeping in mind here in North Carolina that closing is constituting the acceptance of the property in its existing condition. So what that means is all property is sold as is in North Carolina unless otherwise agreed upon. So just keep in mind that everything moves forward even if we didn't agree on, or even if something isn't exactly the way you want it to be in the property, it just needs to be expressly agreed upon. So if something's broken and the seller won't fix it, if you don't want to buy the house because of that one thing, then yes, you can back out. But just keeping in mind that the seller is really under no obligation to do anything. So buyer representation. So this is where we need to be as truthful as possible. We are going to talk about our loan. We're going to talk about what type of loan, FHA, VA, conventional, or other. Are we going to get a fixed rate? Is it an adjustable rate? What's the percentage? what is the term of the loan, 30 years, 15 years. They need to know this information because it tells them as sellers how qualified we are as buyers, how well we can actually buy the property. So very important, but it's important to expressly put that information in there. Now, does it mean that this information can't change? No, it can change, absolutely. It's ideal that it doesn't, but if for some reason the rate changes, or if you decide to go 15 years instead of 30 years, then we can change those. That's not a problem. And of course, as it says here, the buyer is not conditioned upon obtaining or closing any loan. So, meaning it doesn't mean like you want to get a loan, you might have to get a loan, but you're under contract. So if the loan doesn't work out, then you got to either buy the property or back out of the contract and forfeit those monies. So just keep that in mind. Here, this is where we expressly, I guess, say whether or not we have to sell a house. So if you need to sell a condo at the beach, or you need to sell your house that you're currently living in, we will have to put that on here, whether or not you have to do that. If you're renting, then you don't, and you don't have another house that you own, then odds are you're going to say it does not have to sell. Sometimes you have to. But then if you do have to sell a house, we'll do a what is known as a contingent sale addendum and attach it to the back of this contract. And that just basically says, hey, this transaction is contingent upon the sale of my home. And then that actually gives you a little bit more peace of mind knowing that, if you have to sell and you're still in the market, then we can do it. All right, so this just says, hey, you've received a copy of the residential property disclosure, or you haven't. If you haven't received it, then you do have 3 calendar days to receive that statement without penalty, or back out without penalty. So you won't lose any of your money if they don't provide a North Carolina residential property disclosure. Those are usually included in the listing, and I usually give those to my clients as we put in the offer. But if those don't exist, and we ask for them several times, and we're under contract, and it's been 4 days, or 3 days, then we can back out and not lose any money. So that's good to know. It just protects you there. Same with the oil, mineral, and gas rights mandatory disclosure statement. Those 2 statements are pretty important, and we'll go over those later in a separate tutorial. Maybe in person, I don't know. Here we just talk about buyer obligations. So what are you responsible for? You have to pay special assessments that are proposed. Wait, proposed? Didn't I say? Yes, sorry. Okay. You have to pay proposed special assessments. Confirmed special assessments are typically taken care of by the seller. So I may have had that backwards earlier. The seller pays confirmed. Proposed are paid for by the buyer because they're just proposed. I'm sorry. I totally messed that up. Forgive me, and I'm not going to go back and redo the video because I've already talked way too long. So anyway, buyer obligations, you do have to pay for proposed special assessments. You do have a responsibility to pay for certain costs pertaining to the transaction. So any appraisals, title searches, title insurance, fees charged by the closing attorney, fees brought to you by the lender themselves. Any of that, you are responsible for that, whether it be paid at settlement or before. You are responsible for those costs. So just make sure you have a clear understanding of what you need to pay for up front and what you can pay for in settlement, because that's going to determine how much cash you need to have on hand when you close the deal. All right, so then the seller represents certain things on their end, and of course, I'll fill out this for you as well. Have they owned the property for at least a year? Have they never owned the property, or have they owned it for less than a year? And not yet owning a property could be you're performing like a will for someone. You're executing on a will, and you've never owned the property, but you're working on someone else's behalf. That could be a situation where someone doesn't own the property. Lead-based paint, anything prior to 1978 is possible to have lead paint, so the disclosure will be required. If you don't see a disclosure of anything prior to 1978 on a property, then raise a red flag, because you need to know if it has lead-based paint or not. Here are the assessments again. If there are any proposed or special Confirmed again are paid by the seller, whereas proposed are paid for by the buyer. And then owners associations and dues, it'll talk about all that information there. Who is the association? How much of the dues per what? Annual? Are they quarterly? Are they monthly? Who's the manager? What's the website address? Usually we'll put just the name of the association and the dues amount and maybe the manager. I'll put the website if I can find it. And some communities have more than one association if that's possible. And another thing I'll send you to are the declaration of restrictive covenants. That's important to have. So this talks about seller obligations. Just make sure there's clear and present title, that there's not any issues with the title itself and the deed. Also, just making sure the property looks good reasonably when they vacate it. All that stuff is important. Giving you access to the property once you're under contract, that's important as well. Reasonable access. We don't want to go in there every day and have a cookout, but access to investigate, things like that. Good title, removal of property, and debris and things like that. It's part of the contract. So keep that in mind. Deed, taxes, and fees. Seller pays for a lot of those things. You'll pay prorated amount, but we'll talk about that later on. The deed is going to be made out to, it'll be your legal name, and if it's with a spouse, it'll have that information in there. If it's with a partner, we'll have that information in there, and it'll just be quite easy to do that. So not a big deal with the deed, taxes, and fees. Agreement to pay buyer expenses. So this right here is saying that the seller will agree to pay closing costs of any type of amount towards the buyer's expenses. Typically, we'll ask for it if the market or if there's not a multiple offer situation, we can ask for them. If you really need them and you want to see if there's some credits you can get, then we'll go in and put a number here. But just keep in mind that can happen. And then, of course, if you have a VA or FHA addendum, that some lenders may not allow you to pay for closing costs within the confines of the contract. So just keep that in mind as well. I'm sorry, not allow the seller to pay your closing costs within the confines of the contract, because it gets tricky and the government just knows what they're doing, I guess. So just keep that in mind. But yeah, we can ask for settlement expenses here. Let's see. Talks about a lot of different things here. Prorations and adjustments. So you will pay a prorated amount of taxes for property taxes, for real and personal, and any type of homeowners association dues. So sometimes if the taxes have already been paid, then you'll have to pay the seller that. If the taxes have not yet been paid, then you will pay your portion of the year, and then the seller will pay their portion of the year to the government. And then, of course, here's a section for home warranty. Sometimes the sellers provide home warranty, sometimes they do not. Here you can say, no, they're not providing one. Yes, they are. They're going to provide one, and the seller's going to pay for it. Or, they've paid for one and obtained one as well. So just keep that in mind as well. For if you're interested in a home warranty, that we might be able to get the seller to pay for it. If not, then then you can buy one as well, or have the seller pay for one if they agree to do so. Condition of the property at closing is just making sure that everything's good, normal wear and tear. Talk about risk of loss, settlement, delay in settlement and closing. We can delay the closing up to 14 days. It's rare that happens, but sometimes it does if there's some sort of issue. But if we exceed the 14 days, then we are in breach of contract. And the non-delaying party may terminate the contract and should be entitled to enforce any remedies available. So if we breach contract and we move beyond the 14 days, then the seller can come after us and terminate the contract and come after us for the damages, which are your earnest money deposit. So keep that in mind. Possession is kind of a big deal. When do you want it? Typically, we do a possession at closing, But if you want to move in early, you might ask for a buyer possession before closing agreement. And it's an additional addendum, it's an attachment, and we'll include that with the offer. Um, that would just be like a miniature lease, like a little bit of a rent. Like you want to live there for a week or so, get moved in. That's great. Sometimes the seller will require a seller possession after closing, meaning they are leasing it back from you because they have to move into a new home and something, maybe there's a timeline overlap that they need to fulfill. So those are where those issues are addressed, is in buyer possession or seller possession. It's harder to go in at the beginning with those types of things because they're just less desirable by both sellers and buyers. But sometimes that works out, especially in vacant listings. So let me know if you have questions about that because that could be interesting depending on your circumstance. So this section talks about addendas, any addenda that we have, backup sale, backup contracts, contingent sales, FHA, VA loans, lead-based paint, all of that stuff. I think that is where I'll check off the boxes that are necessary here. We go through a few other things about just legal transaction type stuff. Definitely check those out, read through it. And then you get to signatures where you sign on your side and the seller sign on their side. And once everything is signed, you have a contract, ladies and gentlemen. So all of the information here, my information, my firm's information, their firm's information, it all goes in there. It's very straightforward. This is your receipt of monies, so it'll be floated around for the days after going under contract. You'll get acknowledgments of due diligence fee has been released. Has been received. You'll get acknowledgments, of the seller receiving the due diligence fee themselves, the escrow agent. So all of that, everyone will get copies of that, and it's part of the contract once it's done. The lender will also want a contract copy as well. But this is your offer to purchase. It's 13 pages of just pure fun and entertaining. So that's why they pay me the big bucks to go through it with you, but also to deal with it. So hopefully all your questions have been answered. If you do have any questions, feel free to contact me again. My email is steven@costellorei.com. I'm happy to help. And, by now you probably have my information, so give me a call. But this is me going through the offer to purchase and contract with you, and I'll talk to you guys later on. Thanks so much.